you employ people in the UK, your unfair dismissal risk is about to change dramatically. From 2027, the government is expected to reduce the qualifying period for unfair dismissal claims down from 2 years to 6 months. And alongside that, the current compensation cap, which already sits at over 118,000, may no longer operate in the same way businesses are used to. For founders and growing businesses, this is potentially one of the biggest shifts in employment risks that we've seen in years. I'm Babs, I'm one of the founding partners at Jamieson Law. We advise founders and SMEs on exactly these kind of operational and legal risks every single day. And in this video, I want to walk you through what's changing, why it matters commercially, where businesses are most exposed, the mistakes that I think founders are about to make, and most importantly, what you should be doing now before these changes arrive. Because one of the biggest misconceptions businesses have is that they think unfair dismissal claims are only a problem for bad employers. That's not really how these situations arise in practice. Most employment disputes actually come from growing businesses, operational pressure, unclear processes, rushed hiring, poor communication, and reactive management decisions, particularly in founder-led businesses. And this change matters because it significantly shortens the amount of time businesses have before employees gain legal protection. At the moment, in most standard situations, an employee generally needs 2 years service before they can bring an ordinary unfair dismissal claim. That 2-year period gives businesses a relatively significant buffer. It means that if somebody simply isn't performing, if they're not a cultural fit, or if the relationship isn't working properly, then many businesses currently feel that they can just exit the employee relatively easily before that 2-year mark. That mindset is about to become much, much more dangerous. Because if the qualifying period reduces to 6 months, which it is going to, businesses will have dramatically less time to assess performance, document concerns, manage issues properly, and build appropriate HR processes around staff. And for SMEs particularly, that's a major operational change because large corporates usually already have HR terms, formal processes, structured performance management, and internal compliance systems. A lot of SMEs don't. A lot of SMEs still operate through informal conversations, founder instinct, operational urgency, and reactive decision making. And honestly, that's where I think many businesses are liable to get caught out. Because I think founders are massively underestimating how much employment law risk actually comes from operational informality. For example, a founder hires someone quickly because the business is growing. There's no proper onboarding, there's no structured probation review, no documented expectations, no formal feedback, and there's no clear management structure. 6 or 7 months later, the employee isn't performing well. The founder becomes frustrated. We've all been there. Communication deteriorates, the employee feels unsupported. Eventually, the business looks to exit them. Historically, many businesses might have viewed that as a relatively low risk situation. Under this new framework, potentially much, much riskier. Because once employees gain unfair dismissal rights significantly earlier, businesses are going to need much more robust management processes much sooner in the employment relationship. And I think this is where many founder-led businesses struggle. Because founders are usually commercially focused, they're growth focused, operationally stretched, and they're moving very quickly. They often view documentation, HR procedures, employment processes as secondary priorities. We've been there, right? But employment law risk is one of those areas where small operational shortcuts can become very expensive later down the line. And importantly, the legal costs are often only part of the problem. The bigger issue is usually management time, operational distraction, staff morale, reputational damage, and internal culture disruption, particularly in smaller businesses where one dispute can affect the entire team dynamic. Now, one thing I think is really important to say here is that this does not mean that business suddenly cannot dismiss their employees. That's not what we're saying here at all. That is not the position. What it does mean is that businesses will need to become much better at processes, documentation, communication, and consistency. Many businesses should probably already be operating this way, right? Because one of the biggest mistakes founders often make is waiting until problems arise before building proper systems. The businesses that usually manage employment risk the best are the businesses that operationalize early. So that means clear contracts, proper probation periods, documented expectations, structured reviews, training for managers, and consistent communication. Not because they're overly corporate, but because structure protects businesses when pressure increases. And another issue I think businesses are underestimating is manager capability. A lot of employment problems don't actually come from the legal framework itself. They come from poor management conversations and styles, emotional reactions, inconsistent treatment, and badly handled communication. For example, a founder or manager says something casually in frustration, an employee interprets it differently, there's no documentation, no consistency, no formal process, and suddenly what felt like an operational issue becomes this huge legal dispute that was never really the intention. That becomes much harder once employees gain more protection earlier. And I also think this change is going to create major hiring implications for SMEs, because there is a real possibility that businesses become more cautious, slower to hire, and more risk conscious around recruitment because of this change, particularly where roles are junior, performance is difficult to measure, or businesses are already operationally stretched. And that is one of the unintended consequences these kind of changes can sometimes create. Businesses don't necessarily become better employers because of laws like this. Sometimes they simply become more risk averse. Now, from a practical perspective, what should businesses actually be doing? Well, the first thing is review your employment contracts. And I know that sounds really obvious, but many growing businesses, they're still using outdated contracts that were drafted years ago, or they've copied templates, they've got inconsistent clauses, or they've got contracts drafted years ago when the business was much, much smaller, and they're just no longer appropriate. Your contracts should properly deal with probation periods, notice, confidentiality, restrictive covenants, performance expectations, disciplinary processes, and operational flexibility. Secondly, look at your onboarding and probation systems, because if employees are gaining protection significantly earlier, your first 6 months becomes critically important. Ask yourself, how are performance concerns identified? How are they documented? Who manages probation reviews? Are expectations actually clear? Are managers trained to handle issues properly? A lot of businesses realise that they don't actually have a process, they just have assumptions in place and everyone's relying on them. And then thirdly, train managers properly, and this is one of that businesses will massively underestimate, because poor managers create enormous legal risk, particularly managers who avoid difficult conversations or who communicate inconsistently or become emotional under pressure. Employment disputes are often relationship failures before they become legal failures. Fourthly, stop relying on informality as the business scales. This is one of the biggest operational transitions that founders will face. At the start, everything works through conversations, trust, speed, and direct communications. But once teams grow, informality becomes harder to manage on a consistent basis, and inconsistency is where we get the risk growing, particularly if different employees are treated differently, or their expectations are varying, or documentation becomes inconsistent. Now, another thing I think is really important here is that these changes are also part of a much broader shift happening across employment law generally. What we're seeing now is increasing employee protections, increasing compliance expectations, greater scrutiny on workplace conduct, and higher expectations around process and culture. And I think many SMEs are still psychologically operating as though employment law risk is relatively low probability, but that is becoming less and less true all the time, particularly as employees become more informed, social media amplifies workplace disputes, claimant firms become increasingly sophisticated operationally. Now, does this mean businesses should panic? Am I trying to put the fear into here? No, not at all. But I do think that businesses should start to take this a bit more seriously, because the businesses most exposed are probably not the intentionally bad employers. It's fast-growing businesses, it's reactive businesses, operationally stretched, founder-led businesses that haven't yet built proper infrastructure around people management. And I think this links into a much bigger conversation around how businesses operationalise their growth. Because one of the biggest mistakes that founders often make is assuming that legal structure and operational structure are separate things. They're fundamentally not. Employment law problems are often operational problems wearing legal clothes. The legal dispute is just the final stage. The underlying issue is usually unclear communication, lack of process, poor management, reactive growth, or inconsistent decision making. And the businesses that adapt best to these changes are probably going to be the businesses that realise that employment compliance is no longer just a simple HR issue. It's actually a leadership issue, it's an operational issue, and increasingly it's a significant commercial risk for you. So if you're a founder watching this, the key question for you right now is probably this. If an employee in your business gained unfair dismissal rights after 6 months instead of 2 years, would your current systems actually protect you, or would you be exposed? Because for many businesses, the answer right now is probably no, you're not protected. And the earlier businesses start fixing that problem, the easier these changes are likely to be to manage.